1 is now in session.
Thanks, Kim. You may be seated. This is the time and date set for oral argument in cause number CV20-0659, Preszler versus Corin D. Martin, PC. These proceedings are being video and audio recorded as well as live streamed, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes to present their argument. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal should you desire. Also, for your information, we've read the briefs, we've discussed the case, we're familiar with the facts. Please take that into consideration during your presentation. At this point, counsel, are you ready to proceed?
Yes, I am.
And I'd ask you guys to stay at your podium so we don't cross-contaminate one another.
I'm sorry to see you appear to have an accident. Hope you're okay.
Not graceful, but on the road to recovery. Thanks, counsel.
Well, thank you. I'm Richard Hunley. I'm the attorney for the plaintiff and appellant Penny Preszler in this case. It's a dental malpractice case. There are two issues presented by this appeal. We're appealing from the court's judgment of October 15, 2020. The first issue, and it's probably the primary issue, was the court's ruling disqualifying plaintiff's standard of care expert, Dr. Jeffrey Martin. The court held Dr. Miller was not qualified to act as plaintiff's expert under ARS Section 122604. The second issue involves the court's inclusion of a monetary sanction in the judgment of about $19,000. The court awarded it under ARCP Rule 37H. It awarded it, or rather defendant sought it, and the court awarded it because plaintiff at an earlier point in the litigation was required to change its expert witness because the first expert witness backed out. This was after an appeal and after 2 years into the case. On the first issue, 122604, that statute requires that if a defendant is a board-certified specialist, the plaintiff's expert is to be a certified specialist in the same specialty. Baker is the leading case, the primary case on this issue. It sets forth the intent on the statute, and the intent is to ensure experts have qualifications and experience comparable to the medical professional whose conduct is at issue. Here, the defendant was a board-certified specialist as an oral and maxillofacial surgeon. Plaintiff's expert, Dr. Miller, was a board-certified special in periodontistry. And the dental proceeding...
And counsel, you agree or concede that there's a distinction between those two, correct?
No, I do not. Not as concerns dental implant surgeries.
So the record would not reveal that there is a concession on your part that there is a distinction between that? In front of the trial court?
Well, they're two separate. There's board-certified specialties in oral surgery. There's board-certified specials in periodontist. But as concerns the procedure in this case, dental implant surgery, I do not, and I don't think I ever conceded that there was a distinction.
Are you suggesting that Dr. Martin was acting outside the scope of his specialization? So this is encompassed within his specialization?
Yes, yes. And my point is, let me just lead to something. The trial court surmised that the board-certified oral surgeon, the defendant, and a board-certified periodontist, like our expert, would likely be held to different standards of care. That's not true. There was no facts in the record to support that.
But doesn't Baker itself, though, recognize that there can be overlapping expertise, but nevertheless held that you need the same specialization?
Baker is not that hard line. Baker allows some flexibility. I'm going to read you a quote from Baker. First of all, Baker cited a Michigan case that has the identical statute in that state. The plaintiff's expert does not have to match all of the defendant physician's specialties. Rather, the plaintiff's expert only has to match the most relevant specialty. The one most relevant specialty is the specialty engaged in by the defendant physician during the course of the alleged malpractice. Baker added to that, the expert witness need not mirror the specialty of the defendant physician or the elements of the specialty of the defendant physician that are not pertinent to the relevant injury.
But doesn't that mean if he's also a brain surgeon, he has certifications in brain surgery and oral maxillofacial, however it's pronounced, that the brain surgery would not be relevant, we wouldn't care? He was acting within the scope of the specific specialty.
Right, that's certainly one possible application, but I think here it's a little different. I don't think any cases address this in Arizona. There is, well, certainly at this time that we're talking about, there was no board certification specialty in dental implant surgeries. Rather, the evidence before the trial court was there are two specialties that are both experts in this procedure with the same standard of care and the same requirements.
Where do we have same standard of care? Where in the record does it say that the standard of care applied to both equally are exactly the same? I didn't see that.
That was in Dr. Miller's declaration that was provided. And if I see if I can find it for you. Better yet, I'd say the declaration of Jeffrey Miller in response to the defendant's motion to dismiss is an exhibit to our opening brief. He says, let's see.
And that's your expert stating that the same standard of care applies to both.
Correct. The other side did not rebut that.
All right.
So that gets to the bottom line of what we're looking for. We're not saying that the court should have automatically accepted Dr. Miller, because admittedly, there was an issue to be determined to make sure that Dr. Miller is under the same standard of care as the defendant. We just believe there should have been a hearing, an evidentiary hearing.
Was one requested?
Excuse me?
Was one requested? And let me be clear, was an evidentiary hearing? Did you request an evidentiary
We did
hearing?
not request an evidentiary hearing. The issue only arose in the judge's ruling.
Well, at the time that ruling came out, how long had this case been pending?
The case was filed, I believe, in 2015. It was initially dismissed on a statute of limitation issue, I think in 2017. It was in this Court of Appeals for 2 years. The judgment got reversed. So if we take out the appellate period, I believe we're about 2.5 years.
But the case by the time the second standard of care expert withdrew in December of 19 had been pending for 4 years? In other words, there were 3 standard of care experts that you tendered, and we're talking about the third one,
Correct.
which came into play after the second one withdrew in 4 years after the case was filed.
Yes.
And then you and your client were given additional time, I was going to say substantial additional time, but you probably wouldn't agree with that, to find another standard of care expert. No evidentiary hearing was requested. Was there any motion practice in the Superior Court saying, hey, we need an evidentiary hearing?
There was a motion to disqualify the expert. There was oral argument.
Mm-hmm.
I believe, I don't know if we got the transcript for you, but I believe we indicated in the oral argument that if the court should hold an evidentiary hearing, if there's a question about the standard of cares. That issue only got to the top of the list when the court in its ruling said it presumes they're held to different standards of care. The only thing the court had before was a declaration saying, no, they're not. If the court thought that that was a key issue, we should have had a hearing. And again, I emphasize the defendant never contested that point. It never took the position that these two have different standards of care. They didn't put any evidence on by way of declaration or otherwise on that point.
When we look at the statute, and I think maybe this is for the judge's convenience, because one thing judges are not are doctors. So we don't really know how to parse through if you can do this procedure, but you can't do this procedure where you're going to apply the same. That kind of an inquiry is time prohibitive. I mean, it takes a lot of time to get into it. So if we read the statute, it says someone with the same specialty. And if we read that, just as the words say, same specialty, it goes on to say an expert must be certified in the same specialty. So it says it twice. Why are you, and what case do you have that supports, and I know you're stretching Baker to fit what you're telling us today, but what case do you have to support that specialty and board certification aren't applicable if you're qualified to do the same procedure?
There's only a couple cases, published opinions on this. Razor's one of them, but it doesn't touch this point. Baker's the one that's on this point. And I rely on Baker, because Baker says the specialties don't have to mirror each other. You can disregard the elements of a specialty that are not pertinent to the relative injury or procedure. Plus, Baker in no case has talked about the situation where two different board certifications are equally able to do the same procedure. That's the difference here. That's why I think by using Baker, we can slightly expand the interpretation to 122604 to include a situation where two board certifications, two specialties, can both handle a same procedure with the same standard of care applied to them. And if the trial court has an issue with that, then we could have a hearing on that standard of care to make sure that they are both under the same standard of care. And it only makes sense that to be under the same standard of care. I've never heard of a situation where one specialist is held to a different standard of care for the same procedure done by somebody else.
Counsel, let me ask you, with respect to the standard of care, what's your best argument for how that is a part of the 2604 inquiry?
Just Baker's interpretation of it. Baker cites both a Michigan case, and I read you that quote, and Baker goes on with the indication to state that the expert witnesses need not mirror their specialties of the defendant physician that aren't pertinent to the relative injury or the procedure. The relative procedure here is the dental implant surgery.
Do you read Baker as engrafting a standard of care analysis under 2604? Okay.
So and it really comes down to, we have an unusual situation, and part of this was COVID. The plaintiff's initial attorney withdrew on the eve of a motion for summary judgment. I stepped in. Motion for summary judgment was granted on the statute of limitations issue. We appealed it and we prevailed, so it was sent back. We went to that first expert, and he didn't want to be involved anymore. He thought the case was over, and he seems to have come from a package deal with the first attorney. So then we hired Dr. Kotikian, who definitely mirrored the opinions of the first guy, but then his wife was in advanced stages of breast cancer, so he had to withdraw and step back from his practice. And then COVID hits. So the judge worked with us a little bit. He gave us some extra time, but I couldn't find anybody to return my calls during the first 4, 5, 6 months of COVID. So we had Dr. Miller. Now, Dr. Miller wasn't just randomly taken. He has a practice, a long-time practice, primarily involving dental implant surgeries. I believe his declaration indicated he'd done over 700 of them by that time. If anything, he was far more experienced in dental implant surgeries than the defendant. I don't remember how many he testified he did, but it wasn't 700. But there's no reason if we do a mechanical, strict application of 122604, then plaintiff loses. But Baker opens the door for flexibility to ignore what makes specialties different. Dr. Miller set forth in his declaration what the differences are between his specialty and the defendant's specialty. They are, the defendant can do jaw reconstruction surgery, T&J surgery. Both of them can do bone grafts, but the defendant's specialty allows him to harvest bone grafts from the hip. Those are the primary distinctions. Those have absolutely nothing to do with dental implant surgery. And I think the flexibility suggested by Baker should be applied here. With the case returned to the trial court, to have a hearing if there's any doubt as to whether there are different standards of care between these two, between the defendant and plaintiff's expert. I know that's my primary issue. I really want to touch on the other one too, if the court will allow me.
Please.
The trial court stuck plaintiff with $19,000 as a sanction under Rule 37H because she had to change her expert. That was the change from expert 1 to expert 2. The court did it under 37H of the ARCP. No case interprets 37H that way. The statute itself doesn't read that way. What 37H says, it's a rule to achieve proportionality. It talks about compliance with disclosure and discovery. Its application is if somebody is untimely or incomplete with disclosure or discovery, then Rule 37H can give the court the power to make appropriate orders, such as a rule under or an order under 26C, which is a protective order, or an order allocating costs and expenses of discovery or disclosure. But that's in the context of untimely or incomplete discovery. That has nothing to do with an expert. The defendant's case law on this, there's none in Arizona. The ones from other jurisdictions all involve wrongdoing by the plaintiff, where they have a plaintiff they find out at the last second is not qualified or lied on his resume. And there's one case where there was a conflict between the plaintiff and the expert that wasn't disclosed or found. Those are elements or levels of wrongdoing. There's no wrongdoing here.
Counsel, let me ask you, with respect to 37H, you're right, it is titled Orders to Achieve Proportionality, but it strikes me that it affords a trial court almost unfettered discretion in shifting costs. And I guess some of that I get from the amendment in 2018. The comment, Rule 37, I'm quoting here, is amended in several ways to increase the power of the court to promote full compliance with discovery and disclosure rules, which is your point, and thus to help the parties in the court fulfill the important goals in Rule 1, which is the timely, cost-effective, prompt efficiency of resolution. But it talks about as justice requires or may make orders, including without limitation. I mean, it's an extraordinarily broad rule.
Well, I still think it's under the cover of discovery and disclosure.
Well,
on that.
and help me out, but aren't the costs here shifted because the court found that, I'll call it deposition, but preparation and deposition for that first expert had become moot, had become unnecessary? Isn't that, I don't view it as a sanction, I view it as a shifting.
But the court did more than that. Only a small amount of the $19,000 was the actual deposition money.
Well, but there's preparation for depositions, right?
Yeah. But that was with the first attorney. The court then gave attorney's fees for the second attorney just to get brought up to speed on the case. And it also included the cost of an independent medical exam. Well, you had to do that one way or the other. It also included the expert basically duplicating the work. I mean, I don't think it should have been used at all in this way, but it certainly shouldn't have been used to award some of the items, and I outline and specify those in my brief. I do want to make one more point. If we interpret 37H the way we do here, anytime somebody changes an expert for some reason, through no fault of their own, they're going to get a sanction. Your expert dies, you're going to get sanctioned. And that's not the intent of 37H. And 37H says it's to ensure timely and full compliance with discovery and disclosure. It has nothing to do with the change of an expert through no fault of your own. And if I can, I'll reserve 3 minutes.
Thank you.
Thank you.
Good morning, and may it please the court. My name is Callie Maxwell, and I represent the defendants and the appellees in this case. I think your honors have been asking a lot of really important and prudent questions, so I'd like to address some of them first. The first is Baker. Baker absolutely says that if the treatment or care or procedure involved in the dispute is relevant to the physician's specialty, then the expert who is going to render opinions against that expert has to have the same specialty. And it goes on to say if it's a board-certified specialist, then they have to have that same elevated level of qualification, board-certified specialist. That case specifically outlined a situation where the plaintiff's expert was had training and specialty in hematology, but the defendant was in pediatric hematology. And the court found specifically that the treatment at issue was relevant to the pediatric hematology, and therefore the plaintiff's expert had to be a board-certified pediatric hematologist. And the court goes on to say, it's true that both of these individuals could provide this treatment to the patient, but the statute is very clear, and it was written with an intent and with a purpose, which is obviously the legislative purpose. So when we back up to talk about that purpose, the tenets of statutory construction are very clear. If a statute is clear and unambiguous, it should be applied on its face. And that's what Baker did. And you were asked, one of your honors asked about whether or not there was a dispute over the standard of care. Well, the standard of care in Arizona is statutorily driven as well. ARS 12563 says that the plaintiff in this case had to prove that Dr. Martin failed to exercise the degree, skill, and learning expected of a reasonable, prudent healthcare provider, and here's the key words, in the profession or class to which he belongs. So we start with standard of care, which is examining based on class and profession. Then ARS 1226 really builds on top of that, and it uses two specific terms that were intentional, specialty and board certification.
Counsel, let me ask you, on your standard of care argument, you're not arguing that the tendered expert here by plaintiff would not qualify under 12563, are you?
I would argue that, yes, I would. I would argue that he would qualify against another periodontist, but not against a board-certified oral maxillofacial surgeon.
Just looking at 563. In other words, I get you want to talk about 2604, but you mentioned 563, and I'm not with you on that, and I want to better understand that argument if that's a component of your defense.
Well, I just think that they build on one another. The statute of care, or the standard of care is defined within a profession. It's within a group of physicians doing the same thing, and that's why a member of that community is required to render standard of care opinions against that physician. But then the statute goes, the legislature went on further to further specify in 122604, and in Baker talks about the fact that the term specialty was defined by reference to, quote, practice areas in which a physician may obtain board certification, and it said it was a workable approach because it's objectively identifiable, which is what Your Honor was referring to, that judges should not have to parse through whether or not one physician, you're not medical doctors, one physician is qualified to testify against another. It's a bright line, distinct rule, and it also goes on to say, and it reflects recognition by certifying bodies that certain practice areas involve distinct training and experience, which is true here. And Dr. Miller's affidavit acknowledges that. There are several paragraphs where he talks about the difference between a periodontist and an oral maxillofacial surgeon.
Counsel, can I ask, when, if ever, is there a need for an evidentiary hearing? Under what circumstances? If we can just look and say these two doctors do not share the same specialty, is there a situation in which an evidentiary hearing is warranted?
Your Honor, that's a good question. I don't believe so here. The statute does not provide for an evidentiary hearing in these circumstances. The only situation I can foresee where that would be necessary is if there's a dispute where a plaintiff, for example, says, my expert is board certified in oral maxillofacial surgery, and defendants do investigation, they check the board and they say, no, you're not, and there's a dispute over that, then perhaps an evidentiary hearing is warranted. But the statute is very clear that the purpose of it is to make sure that it's like versus like, that the qualifications, experience, and training of a physician criticizing another physician mirror one another. And so the idea that an evidentiary hearing needs to be held in order to determine what that standard of care is in direct contradiction to the plain language of the statute. The statute's very clear on that level. And in fact,
So before we go on, was an evidentiary hearing requested at any time in the Superior Court hearing?
based on my recollection, no. I do not recall that at any time. I did not review the oral argument referenced by opposing counsel in preparation for today, so I have to give you that caveat, but I do not recall an evidentiary hearing being requested.
Would a hearing be warranted if there was an assertion that the procedure being performed was not within the scope of the expert certification? Would that be an example maybe of when one would be required?
I think that's a good point. I think that could come into play, but there's no dispute about that here. Both parties acknowledge that the dental procedure performed was within the scope and specialty of Dr. Martin as an oral maxillofacial surgeon, and we cited to the American Board of Oral Maxillofacial Surgery for their position statement on that. And again, that was not disputed here. I think also it's important to recognize the way the statute's written in sort of a hierarchy fashion. First, as Your Honor points out, it talks about a specialty, and then it builds on that and says, if you have that specialty and you're board certified as a defendant, the person that's going to give testimony against you must also have that higher level of distinction.
If we put aside the statute and we just look at the two experts that are offered here, they both do the exact same procedure. Is that correct?
I would not dispute that.
Okay. Does the standard of care vary based on board certifications? Just out of curiosity.
Yes, Your Honor, it does. And here's an example for you to take it out of this context. Both general surgeons and colorectal surgeons do surgery on the bowel. They both have privileges to resect the bowel. They may have different techniques. They've been trained differently. They have different specialties. And sometimes they can perform the same procedures and sometimes they can't. A general surgeon has a greater scope of surgical scope than a colorectal surgeon. So just because two professionals can perform the same surgery does not mean that the standard of care is the same for both. And in fact, in my example in particular, I think the standard of care would be higher for a colorectal surgeon doing surgery on, for instance, the rectum or the bowel than the general surgeon who's does more of a wide range of surgeries. But again, that standard of care is defined by statute, and it's defined as a reasonable, prudent person in the same or similar profession or class. And so just because two medical professionals do the same procedure does not mean that one can render opinions against the other.
Thank you.
The other important point is ARS 1226 does not carve out any qualifications or exceptions. And if the legislator intended it to have those, it could have done that, but it chose not to. So just to make sure that I have a little bit of time for the second area here, I just want to clarify that plaintiff was given a substantial amount of time. I know Your Honor, Judge, said that you weren't sure that plaintiff's counsel would agree, but it was a substantial amount of time. This was from December of 2019 to August of 2020. That's almost a year, 8 months. The statute that requires an expert affidavit requires that it be disclosed with the initial disclosure statement. So the legislature intended for these issues of expert testimony to be ironed out early in the case. And it was intended to weed out, cases that were frivolous or not meritorious. And I'm not saying that because the original expert met that standard. And in fact, plaintiff retained 2 different experts that had sufficient qualifications, and that's why we didn't file a motion on either one of those. That's why we proceeded through discovery with Dr. Hoagland. And same with Dr. Khati Khan, I think that's how it's pronounced. So 8 months is a long period of time, considering the statutes, the rules and the statutes requiring that this issue be resolved fairly quickly, within 40 days of the initial disclosure statement. Again, that's not directly applicable here, but it shows that giving someone 8 months to find a new expert, especially, within the trial court's discretion, is sufficient. The Superior Court has to have the discretion to run their own docket and their courtroom and to apply and make decisions within the bounds of the applicable civil rules and statute requirements. And based on the evidence provided at that time, which was not very much, we were not provided with any evidence on what steps were taken to try to find a new expert. We were not provided with any evidence on when that inquiry started. We were provided with no explanation as to why Dr. Hoagland withdrew from the case.
So that's a different question than whether the most recently tendered expert qualified under the statute.
Correct.
Would you agree?
Yes, that's a very different issue. But it goes to the reasonableness under an abuse of discretion standard of the trial court under Rule 37H, which I agree was not a sanction. It was a cost-shifting measure out of proportionality and in the interest of justice, because defendants, the court ruled that defendants should not be obligated, it was forced to bear the burden of the financial burden, associated with the switching of experts. And that's within the trial court's discretion. And the comment to Rule 37 makes that very clear.
Counsel, 37H has been amended fairly recently to expand and to account for the kind of three-tiered discovery set that Arizona's adopted fairly recently. But it's been around for a while. What's your best case decision supporting your position under Rule 37? Because it seems like the Superior Court applied it in an atypical way in this case.
Well, we cited a few cases. Now, granted, they were from other jurisdictions. I do not have any case law in Arizona directly on point. But the rule itself is pretty broad, and it says that at the entry of any order allocating costs, expenses, and attorney's fees of discovery and disclosure amongst the party as justice requires. And the attorney's fees that were sought here were dealing with both disclosure, expert disclosure, and discovery, depositions, setting depositions, all of those tasks. I mean, it was scheduling depositions, keeping the client updated on information that had been disclosed by Dr. Hoagland, reviewing Dr. Hoagland's disclosure. You can't just take an expert's deposition. You have to prepare for it. You have to discuss the expert's opinions with your expert and get their take on it. And it's
Counsel, wasn't the request though really targeting the first disclosed witness, not the second or the third?
That is correct. There were no fees associated with the third expert requested. There were some fees that were requested on the second expert because we engaged in a motion practice to preclude the expert, and then the expert ended up withdrawing, and so that whole exercise was for naught or moot. But the court, and that's an important point, the court parceled through the application for fees, and the court did not award all of the fees. We sought $26,000, little more than that, and the court only elected to award 19. And much of that was discounted, was the requested fees associated with the second expert. And so the court did an analysis of what was reasonable under the circumstances and found that $19,000 in change of attorney's fees, expert fees, and costs associated, such as deposition transcripts, were warranted here. And then the other important thing is the issue of proportionality was never raised before the trial court. And there was no motion for some reconsideration filed or challenge at any time, particularly after the court decided that correctly decided that Dr. Miller wasn't qualified. The shifting of the fees was aimed at remedying the problem that defendant would have to incur, do all of these tasks twice. And so, without a motion for reconsideration, without raising these issues below, they're waived here. And so, there was no analysis of proportionality under Rule 37H done in the briefings. And again, the court didn't just award everything. The court went through the application, elected to permit some fees, rejected others, and the minute entry associated with it was fairly lengthy and provided a lot of description. And again, another important point is the defendant filed a proposed form of judgment and a notice, and plaintiff never objected to the form of judgment. So if there was an issue...
Well, counsel, if the form of judgment corresponded with the orders that plaintiffs objected to, there would be no reason to object to the form of judgment, right? That's a ministerial thing as opposed to a substantive thing.
Well, I would argue that it could be both if the circumstances had changed, if plaintiff felt that since the case was going away, those fees should no longer be shifted because there was no duplication of work. That would have been a good time to raise it. In addition, and it was a small point in plaintiff's opening brief, but Kelly Martin was, Dr. Martin's wife was listed in the judgment, but she was dismissed from the case. So there's a ministerial issue that should have been addressed at that stage and was not. There were several opportunities to raise concerns prior to today, or prior to filing a notice of appeal, and they were not raised. With that, I think unless there are any other questions, I will.
I'd just like to go back and talk a little bit about the specifics of the expert's qualifications. And I don't see in the affidavit that he says I am qualified to testify regarding the standard of care for this specialty, even though I only have this specialty. But what he does is say the applicable standard of care in paragraph 3 is to do this, that, and the other thing. As far as standard of care, does it vary from specialty to specialty when it's talking about oral surgery, if you're doing the same exact procedure? I get the bowel reduction, and I get it doesn't seem like there's a varied standard of care given that they're doing the same thing. So you're saying it could be a heightened standard of care. Wouldn't that inure to the benefit of your client if the periodontist was applying a lower standard? This is not making any sense. Are you getting it at all?
Yes, I am. And let me employ maybe a more direct example of like stitching up a scar, or fixing a scar. A general surgeon and a plastic surgeon both do that. But to say that a plastic surgeon, you go to a plastic surgeon for that specialty, that expertise of making the scar small and discreet. You select that person based on their education and training. Dr. Martin is an MD. He has a higher level of expertise and training here. And so to say that anybody who does dental implants can testify against anybody else that does dental implants is the equivalent of saying that the general surgeon whose scar is a little bit wider than the plastic surgeon should be judged under the same circumstances when they've undergone different training, different education. They approach procedures differently. And there was no, number one, Dr. Miller's affidavit, or Dr. Miller's declaration is unsworn. It's not an affidavit. I think that's problematic from an evidentiary standpoint.
But it wasn't disputed.
It wasn't disputed, but again, I'm not sure that it...
Before we go down that rabbit hole, isn't the conversation we had exactly what 122604 is adopted to preclude? Like, we would have this in every single case in which board certification or certification differed, would we not? We'd have to parse through all of this.
Yes, it would happen all of the time. It would happen routinely.
And so is it your opinion, based on your review of the legislative history, that this is precisely what the legislature was seeking to preclude from judges' purview?
Yes, I think the legislature intended it to be clear, and I think they intended it to be an objective line that could be applied very clearly, and unless there's some sort of dispute over someone's qualifications, meaning someone says I'm qualified and they can't substantiate it, it was supposed to be clear so that the defendant is being judged by a member of his or her own profession and class that received same or similar comparable training to that individual. And it's an equitable issue, and it's a legal application issue. We could have a nurse doing a stitch and a doctor doing a stitch, and all of a sudden, the nurse can say that the stitch was done wrong, or vice versa. What if a doctor came in and said to the nurse, you did the stitch wrong? Obviously, the doctor has higher level of education and training. That is specifically prohibited here so that the nurse gets a fair shot, so that the nurse's care is judged based on what a reasonable nurse would have done in the same or similar circumstance. Thank you,
counsel.
Thank you. I'm going to probably be too quick here, but give me a chance. First of all, Dr. Miller's affidavit or declaration was under penalty of perjury. Second, The proportionality issue was raised in our opposition to the Rule 37 request for sanctions, or whatever you want to call it. We even said that in looking at proportionality, you have to look at the relative standing of the parties, compare defendants' resources with plaintiffs', and we have a declaration from the plaintiff that she's unemployed and really doesn't have any resources, that if she's ordered to pay this, it ends her case. Going back to the legislative intent, I very much disagree what counsel responded to your question. The legislative intent found its way into Baker. The intent was that a plaintiff's expert mirror the defendant's qualifications, training, and experience. That was the intent. It wasn't to relieve trial courts of any other.
But counsel, wasn't the inquiry in Baker, I mean, it just involved whether somebody was a pediatric hematologist compared to a regular hematologist in a case that involved a 17-year-old, where your argument, I think, is intuitively compelling, just as it was intuitively compelling, but rejected in Baker.
Baker is distinguishable. Baker is different. In Baker, plaintiff's expert, if he was the one who treated the plaintiff, the 17-year-old, he could not do so within his specialty. He was not a pediatric hematologist, or whatever the phrase is. Here, Dr. Miller, if he was the one that did the surgery on Ms. Preszler, the plaintiff, would be acting within his board-certified specialty. That's the distinction.
I'm sorry, and I apologize for taking up your time, but are you saying the expert, I don't remember the specifics in Baker, the proffered expert was a pediatric, or was not a pediatric hematologist?
The defendant was a pediatric.
Okay, but you're saying he could not have, the proffered expert could not have done the procedure or whatever happened just because the patient was 17 years of age?
No, the proffered expert could certainly treat the 17-year-old, but he would not be doing, he'd be doing it within his experience, within his qualifications, but not within his board-certified specialty. He was not a board-certified specialist in pediatric hematology.
But the procedure itself was presumably the same on a 17-year-old as it would be on an 18-year-old?
I have no idea. Baker doesn't get into that at all. But the distinction here is our expert could have provided the same procedure to the plaintiff within his specialty. This is not the rabbit hole that I think you're worried about. There was no board-certified specialty in dental implant surgeries at the time. I understand, but have not verified that there is one now, so this is never going to happen again. At that time, this falls in the gaps. We have two specialties, and they cross, and they allow this procedure to be done. There is just no reason under Baker or under 122604 to exclude Dr. Miller. And if there's a question in the trial court, I mean, the issue of the evidentiary hearing came up because, and I can't remember if I asked for an evidentiary hearing or not, it's been too long, I'm sorry. But the issue came up because in the judge's ruling, he surmised that there was a different standard of care. And my response is, well, if that's your issue, Judge, have a hearing on it. Don't disqualify my expert because of guesswork. So, clock struck 0. Thank you for your time.
Thank you. Thank you both for your arguments this morning. We will take this matter under advisement and issue a written ruling in due course.
Thank you very much. Happy holidays to everybody.
Happy holidays
you.
to everyone.